All right, court will resume here with the June 6, 2022 docket. And by the way, we're on YouTube live stream. And I have Mr. Rubio Salinas. Good morning, sir.
Good morning, Your Honor.
It is your case. I believe it's F25 39-21-4. And I'm waiting on, is it Adra?
Audra Palacios is on the other side, Judge.
Okay. She's connecting. It's a motion to withdraw. Whose motion is it, Mr. Salinas?
It's mine, Judge.
Your motion to withdraw. Okay.
Yes.
What are the name of the parties maybe there?
Are there any parties that's supposed to be on the?
What are the name?
What's your client's name?
My client is Brian Solis, Your Honor.
Brian Solis. I think he's on. Let me see if I can get him out. All right, that's Brian Solis right there. I can see him already.
Oh, the office can call Audra to check her computer.
Okay. Okay, Rick, can you call Mrs. Palacios Cruz office?
Yes, Judge, I'm on it. Thank you.
Okay. We can do this one. Four. Number four, that'll be number four. I think I have Discover Bank versus Hector Martinez, CL 21-2089D. There's Mr. Salinas. Good morning.
Good morning, Your Honor.
And then we have Mr. Smith, Andrew Smith. Good morning, sir.
Good morning, Your Honor.
Folks, and what do we have here? Is it the motion for summary judgment?
Your Honor, we'd like to pass on this.
I'm sorry?
We'd like to pass on this one, Your Honor.
We've
reached a settlement agreement. Settlement documents should be going out to Mr. Salinas in the coming days.
Okay.
So plaintiff does not want to proceed on this. So yeah, we've settled. We'll get documents out, and then we'll get everything filed with the court.
I have no objection to that, Your Honor, if the court will allow me to read the settlement agreement into the record.
You want to read it right now?
Yes, sir.
Sure. And once again, we're here on CL 21-28-59D, Discover Bank versus Hector Martinez.
Your Honor, Robert Salinas for Mr. Martinez. If it please the court, I have talked to Mr. Smith and we have introduced a settlement agreement whereby the total balance of $13,814.82 would be paid off at the rate of 50% of the amount owed, and that would be paid off in the manner of one payment of $3,500 to be payable within 14 days or 2 weeks from today.
Mm-hmm.
And 12 payments in the next each month following thereafter of 10 payments of $310 and a final payment of $308, and that would be the totality of the payoff. $3,500 one lump payment in 2 weeks, followed by 10 payments of $310 and a final payment of $308 for the totality of the debt. And that is the totality of our agreements, Your Honor, and I would trust that Mr. Smith will get the paperwork forthwith.
Yes, Your Honor. All that I had to add was that this will be filed with a Rule 11 settlement agreement and then secured with an agreed judgment for the full balance.
Okay.
A judgment for the full balance or a judgment for the payoff?
A judgment for the full balance, and the Rule 11 will stipulate that we won't execute, that we won't file an abstract, we won't collect on the judgment as long as the payments are made. And once the payments are made, then we'll file a satisfaction of judgment with the courts.
So long as it is specifically stated that the totality of the payment will be the amount that I've just quoted into the record.
Okay.
Yes, that is correct. So there will be, Your Honor, there will be two different numbers. One on this Rule 11 settlement agreement, that will be the settlement amount, and then the agreed judgment will be for the full balance. But
Right.
it states in the Rule 11 that we agree to that, and that excuse me. I apologize, Your Honor. I'm in two different courts right now. I'm listening to two different things. But that we won't execute on the agreement, that we won't do anything else. Once the payments are made, we'll file satisfaction of judgment with the court, and we'll call it good.
Okay.
Well, I'm a little fuzzy too, Your Honor. I've been in 3 courts and I'm twice as old as Mr. Smith is.
Oh my goodness. I better let you guys go. Okay. You'll have a great day. Stay safe.
Thank you, Your Honor.
May I be excused, Your Honor?
Yes, sir. You may be excused. Thank you, sir.
Your Honor, this
Bye-bye.
concludes my visit for this honorable court. May I be excused?
You'll be excused. Thank you, sir.
Thank you, sir.
Number 9. All right, Mr. Number 9, that'll be F2539-21-4. In the interest of Sammy Lee Mendez Solis. And we have Ms. Sandra Cruz and we have Mr. Salinas. And it's a motion to withdraw, right, Mr. Salinas?
It is, Your Honor.
Your motion?
It is, Judge.
Go ahead.
I'm asking the court to grant it, Judge. The client desires to hire another lawyer.
Okay. Motion to withdraw as attorney, right?
Yes, I'm asking the court to allow me to.
All right. All right, Ms. Cruz?
Your Honor, we have no objection and we have nothing set before the court this morning.
All right, then here it is hereby granted. Did you submit an order, Mr. Salinas?
There should be one with the motion, Judge.
Okay, then it is granted and we'll sign it later. Okay, sir?
Thank you, Judge. May I be excused?
All right, thank you very much. Y'all may be excused. Have a great day. Bye-bye.
Thank you, Your Honor.
Yes, ma'am. Bye-bye.
Number 5, 6, and 7.
Number 5, 6, and 7. 5, 6, and 7. You're talking about F 1437-21-4 in the matter of the marriage of Silvia Cáceres and Hector Cáceres. Yes, sir, Mr. Flores and Mr. Vasquez.
Good morning, Your Honor. Gilbert Vasquez on behalf of Ms. Cáceres, Your Honor.
All right, good morning, Mr. Flores. You need to unmute.
Morning, Your Honor.
All right, good morning, sir. Yes, sir. Gentlemen, what do we have here?
Morning, Your Honor. I have I believe 3 motions are set, or my 3 motions are set today. We have a motion to compel. Roby and I are trying to work on that right now. We started on Friday and today, this morning.
You're continuing, okay?
Yes, Your Honor. And then we have a motion to appoint an evaluator. I have not been able to speak to Mr. Flores about that if he's opposed to that, to evaluate the LLC that was open during the marriage.
Okay. Then you'll have somebody in mind?
I've used Preston Hendrickson in the past. Roby, do you have anybody?
Well, not anybody that charges less than 10 grand.
Okay.
I mean, that's what they're going to charge to do a business evaluation. I mean,
No matter who?
pretty much, Judge. Business evaluations, my experience has been when I've had these businesses evaluated.
That's what it is.
Huh?
That's what it is.
That's kind of what it runs. We don't have that.
I don't.
Okay.
I didn't pay Preston Hendrickson $10,000, Your Honor. But either way, I mean, we have to get it done, Your Honor. And if that's the case, we'll go ahead and look at right now we're trying to get all the bank statements because we have some issues doing that. I believe that the business has enough money to pay for that, Your Honor. We'd be asking for the business to pay for it, Your Honor. My client does not have the income that Mr. Cáceres does, Your Honor.
Well, but Judge, we also have a concern, and I mean, we can address that if we're really, if we can't figure it out between ourselves, what we think this thing owns, at the end of the day, this estate owns some real estate that has some value. The LLC has some inventory that has some value. Other than that, this isn't one of those businesses that you can go out and sell to Gilbert Vasquez or Roby Flores and think you're going to make money at it. It's got a lot of to it. And
Well,
so on the other hand, we also have our own concerns that Ms. Casares took $100,000 check that we don't know where it's at. And we know she endorsed it and we know that it's been cashed, but we don't have access to it. We wish we did. And it had to do with an insurance claim. What I'd like to do, what I'd like to do, if we can, I'd like to finish getting out whatever documents Mr. Vasquez can look at in terms of the banking statements. We know what the appraisals on the property are, and take a stab to see in the realm of possibility what we think the value of it is. If we're that far apart, then let's go spend these people's money. But they need to realize that I don't think there's an account out there that has $10,000 to pay an appraiser. But at the end of the day, once he looks at the accounts and he can say, hey, Judge, there's money here to do it, then God bless him, you know? But if Gilbert, if you think we can get you the rest of those bank statements, figure out where the money is, figure out the values of the property, then let's take a stab at it before we go get into a business report. That's my suggestion.
Your Honor, and that's fine. I just don't want to have an issue where we are going to take a while to come back to court, Your Honor, or I know that Mr. Flores is very busy, Your Honor. It's been very difficult to get some information, Your Honor. And this morning, there's a number of statements or a number of bank accounts that are popping up in the statements he has provided. I've been asking for over a year for this information, Your Honor. So it worries me to take so long to I guess what I'd like to do is let's go over this. I'm sorry, Your Honor.
What I was going to say is give yourself 30 days or 60 days to come up with a value. And if you don't, then so-and-so is going to get appointed to be the appraiser.
We could do that, Your Honor.
Give yourself a limit, you know?
Yes. How about 30 days, Your Honor? And again, the only problem I have with what Mr. Flores said, that this business, yes, we do have some property and inventory in there, Your Honor. However, it's more of a cash-based business and money is flowing in and out, Your Honor. We had one transfer of $37,000. That was just one that we saw, Your Honor. And again, we have not seen statements since last year, Your Honor. So there is money there, Your Honor. And my client is around the business and has noticed the business is still the same, Your Honor. So that is fine, Your Honor. If I can just work with Roby to get those statements, Your Honor. And just to make another note, Roby, this morning with the statement you provided me for the first time, I see another account that popped up, 1757. I've never seen that before. I don't know if that belongs to the father or to this man. I don't know.
I don't either.
So it's
We'll have to check.
It's been very difficult, Your Honor, trying to piece all this together. And it worries me because money's flying in and out. And we have another motion to modify temporary orders to get more money from this individual to pay my client, because she does not have the kind of money that this individual has, Your Honor, to pay lawyers and to pay experts or anything like that, Your Honor. So we'll be coming back on that one. And I'll be addressing the motion to compel with Roby, Your Honor. If you could just give us, I guess, a couple, maybe 2 weeks. So if we don't resolve it, we already have a date to come back, Your Honor.
Okay. So you don't have any more dates? I mean, you got a future date already, or you don't?
I don't, Your Honor.
If you can give us a date in about 30 days so that we can try to come up with a value if we can. If we can't,
Then let's do like a status hearing or something?
The only thing is, Your Honor, I'd like 2 weeks for the motion to compel, Your Honor. I'd like to get everything in. I don't want to have to try to reset something or get a hearing date, Your Honor, and y'all get busy.
Motion to compel in 2 weeks. Can that even be done?
I don't know. I need to look at the calendar.
No, submit an order, I guess, and we'll get you a date because we need to look at the calendar.
Yes, Your Honor. I'll do that. No
that's
problem.
fine, Judge.
Yeah, submit an order on the motion to compel, right?
Yes,
Yes,
Your
sir.
Honor.
All right.
What's that new account number, Gilbert? 1757?
Yes, I saw it in the PNC account you just gave me.
Okay, I'll figure it out.
Yeah, Your Honor.
All right.
The only other thing that we have, Roby, and I'll just, we can come back on this one if we have to, Your Honor. The only thing is that we have a Rule 11 agreement where we had agreed to certain items of the rental tenants, Your Honor. Mr. Casares and his daughter have been going around telling the tenants that they are the only ones to be collecting the monies. That is kind of slowed down somewhat, so I don't really need to urge that motion, but if you can just address that with your client, Rody, please.
Yeah, and we'll be filing our own motion, Judge. She's not depositing the rental money, but that's for another day, and I guess we can hear everything at the same time at that point.
And she is, Your Honor. They both open separate accounts, Your Honor.
Okay.
All right.
All righty. Thank you all very much. You may be excused. Have a good day, guys.
Thank you, Judge.
And bye-bye. Give me we're gonna bring next. Gabriel, and which is that case?
Number 8.
Number 8. Number 8. All right, number 8. Court will resume here with the June 6, 2022 docket. And I have F1757-21-4 in the matter of the marriage of Fernando Davila and Lisa Maria Molina. And I think Ms. Williamson is connecting.
Wait to see who this is.
Rick Salinas and Abel Flores just to this hearing. Obviously, Judge, I'm on the road. And
Okay.
if I get disconnected, Mr. Flores is going to help me out.
All right. He's got your back. Okay.
Kinda,
Mr. Abel
sorta.
Flores. There you go. Mr. Flores, he's connected. He just needs to unmute. And we're waiting on Ms. Williamson.
Good morning, Your Honor.
Good morning. Now there's Jay. Who's that Jay? Number 507-295. Jay.
I don't know. Oh, that's my client, Judge.
No, it's not. It's Pepe Caso. I think I got admitted to the wrong room, Judge.
Oh, okay. All right.
Yeah, we're
Which
waiting
is-
on another hearing.
Okay, which is your case? We got him already.
I've got it. I don't have it in front of me.
Number three, I think.
We can take care of
Number 3. All right,
it.
that'll
It's a
be.
default.
It's a default, right, Mr. Casos?
Yes, Your Honor.
All right, it's CL 2114. I'm sorry, CL 211942D. Joe Vargas versus Super Alca LLC. Fernando R. Sanchez. Is a default judgment as to both defendants or any one of them?
No, only against Fernando Sanchez, Your Honor.
Fernando Sanchez. There we go.
Yes.
Is Fernando Sanchez in the waiting room? He is not. Well, then court will take judicial notice of the entire file in CL 211942D, Joe Vargas versus Fernando R. Sanchez. Yes, sir, you may proceed.
Your Honor, this is a motion for default judgment for pretty much a unfunded check. There was a check issued for $33,000 that had no funds in it, by Mr. Fernando R. Sanchez. The lawsuit was served on him on March 4, 2022. The number of days required have already been passed. We've had the pleadings and on notices on the court's registry. We also had the affidavit of military status and the certificate of last known address on file. And we've provided him with multiple notices. We actually spoken to him on the phone, and he's just appearing not to want to participate in the process. So we're asking for a default judgment exactly for the amount of the check, which was for $33,000, Your Honor.
All right, then court will hereby grant default judgment in favor of plaintiff. Court will grant plaintiff or relief request to hear in open court or in his petition. Court will await a default judgment for signature. Anything else, sir?
Not at this time, Your Honor. Just if I could.
All right. Did you submit the judgment already?
I think I did. I'm not sure, but I'll double check.
Yes, just make sure, please.
I'll
Okay,
let-
you're excused. Thank you, sir. Have a great day.
Thank you, Your Honor. Bye-bye.
Thank you. Okay, what's the next
Number
one?
8.
Number 8. Let me see here, number 8. I think Ms. Williamson is already on, and she needs to unmute. And we have here F1757-21-4 in the matter of the marriage of Fernando Davila and Lisa Maria Molina. All right, it's good morning, ma'am.
Good morning, Your Honor. Lucy Williamson here for Ms. Lisa Maria Vasquez Mori.
All right,
And it's on our motion for new trial, Your Honor.
okay, good morning. And Mr. Flores?
Your Honor, Rick Salinas and Abiel Flores. I asked Mr. Flores to help me out in case I get disconnected. I'm in Austin at a doctor's appointment. I was just going to suggest that I don't mind if Ms. Williamson wants to go first and argue her motion. I'll respond. I filed a written response as well, Judge, along with a couple of cases. But I am on the road. That's why I'm not on Zoom. I'm actually on the road.
All right, very well. Okay, then court will take judicial notice of the entire file. Yes, Ms. Williamson, you may proceed.
Thank you, Your Honor. Please the court. Your Honor, we filed this motion for a new trial for several reasons. Our first reason, on the date of the final hearing for divorce, Ms. Morin's attorney had previously withdrawn. She had no attorney. She was not given an opportunity to get another attorney. She did request of this court on numerous occasions that she wanted an attorney. She wanted to have time to hire an attorney, and the court went forward with a hearing. There was no evidence presented as to custody, child support, medical support, how the property was to be divided. In fact, as to the possession and access of the children, Your Honor, Mr. Salinas repeatedly said, and I have the video of the hearing, Your Honor, he said that all terms were to remain the same. That's all he was asking, is for terms to remain the same. That the temporary order had 1 week each party, when in fact the temporary order did not have the 1 week, nor had they ever exercised the 1 week prior to that, Your Honor. There was no discovery that was provided to Ms. Morin, whether through her attorney. Her attorney withdrew because she could no longer pay, because previously Mr. Varela had been paying her. My client was unemployed at the time, has been unemployed or had been unemployed during the entire course of the marriage. Ms. Thompson withdraws, rightly so, because she could not hire somebody. My client wanted an opportunity to be able to hire somebody. I know during the hearing, Mr. Salinas kept repeatedly saying, well, you're in an attorney's office, you're in an attorney's office. She was in fact not in an attorney's office, she was at a home. So at this time, Your Honor, we're saying that there was so many issues that were not discussed, issues as to vehicles. My client was left with 0 vehicles. Whether there was any retirement, whether there's spousal maintenance, there was no evidence as to any of that during the hearing, Your Honor. It was simply, we want terms to remain the same as per the temporary order, when the terms didn't even remain the same on the divorce decree. It is for that reason, Your Honor, is that I'm asking for a new trial, Your Honor.
Okay. Yes, sir. Mr. Flores?
Your Honor, I'll
Yes.
respond, and Mr. Flores had to address that one case that we provided, and again, in case I get disconnected. Obviously, with everything that Ms. Williams, with all due respect to her, I disagree. And I'd invite the court to look at the transcript, because and the court was there. You may have an independent recollection, Judge, of what was actually asked of Mrs. Varela. I call her Ms. Varela because that's my client's last name, and right now I'm driving, I don't have the file in front of me. But if you remember, this case had been pending for more than a year, Judge. This case was filed either in 2021 or 2020. And it then proceeded to mediation, and we weren't able to get it resolved, all right? And even prior to that, Your Honor, I think that there's portions of what Mrs. Williamson is saying is correct. He had provided point, Judge, Judge, can you hear me?
Okay, you broke down there.
Right.
For a while.
But if you look at the transcript, Judge, and you can figure that out for yourself, I don't agree with Mrs. Williamson's recollection. Number 2, Judge, when Mrs. Thompson withdrew, again, I don't want to argue outside the record, but I think it's important because Ms. Williamson just did that. And in a motion for new trial, you're not allowed to do that. But my understanding from Mrs. Thompson's withdrawal was not because for lack of funds. The agreement that they had, she's correct. It was an extended possession order. However, that was right on the cusp of a hearing that we were going to have in front of you. Prior to that, these couple had been working on a 50-50 order. And how do I know this? Is because Mrs. Williams' client was asking my client to take the children 50-50. There's text messages to that effect. Not only that, Judge, Ms. Williamson may not know this, but Dr. Guilatan was involved in this as well, and she was recommending 50-50. The other thing that's important when you talk about the issues concerning child support, my client, if you look at the record, and I invite the court again to do it, you'll find out that he's paying the maximum amount for 2 kids. It's either $2,300 or $2,500 a month that he's paying for both kids. And he's got possession based on the judgment that you granted 50% of the time. The other thing, Your Honor, is that my client took all the debt that they had. The vehicle that Ms. Williamson is talking about is a vehicle that was being leased. The lease had to be paid. Subsequent to that, I think the vehicles was sold, and there's monies in trust that are being dispersed to him and to her. So there's nothing else that's left. The real problem here is that I think that Ms. Williamson was looking at is that she was asking for a lawyer at the time of the hearing. Again, she's not entitled to it, not under the case law that we submitted. But if the court remembers, when Ms. Thompson withdrew, she got about 60 days to hire another lawyer, Judge. I could be wrong, maybe a little bit less than that. And the reset date was contingent. Okay, Ms. Williamson may not know this. The reset date was contingent on her getting another lawyer because of the age of the case. The court had already warned us that we needed to get this thing resolved. And that's what we did on that day. In fact, your staff had asked me to call her the day before, and I called her the day before to see if we could work something out. And in fact, much to my chagrin, what Mrs. Williams' client was trying to do was not even abide by the abbreviated order that we had right before the hearing. She was actually regressing from that. And she wanted less than that. She wanted to give them less than that. And this is what prompted Mrs. Thompson to get out, because she wasn't able to understand that under the family code, at a very minimum, my client would get the extended standard. So one of the things that you heard of, and again, a lot of this stuff is not relevant in a motion for new trial, Judge. What's only relevant is, did she get a hearing on the day that you rendered the judgment? She was allowed to go forward. She was allowed to testify. And the court even asked her questions. I asked her questions. Mr. Varela testified. And with reference to the kids, he gave, again, without going through all the details, Judge, Mr. Varela testified that it was in the children's best interest that they spend half and half of their time based on everything they had been doing with the kids. Again, they had been evaluated. Dr. Guilatan had been involved. The children themselves had expressed a desire that they wanted to spend half of their time with dad.
Your Honor, and I'm going to object to any hearsay. I know this is just a motion, but now we're going into what children says.
Well,
None of that was in testimony, Your Honor. None of it. And if I ask the
Ms.
court,
Williamson, please, Ms. Williamson,
Okay,
I didn't interrupt you,
okay.
and I don't want to get into this, Judge. I don't want to get into we go back and fro because she's got a habit of doing that. I'm just asking the court that don't take my word for it. I want the court to take judicial notice of the files on document, which has got a long extenuating history, Judge, and look at the transcript. If the court wants to, I can get it, or the court can ask for it. And based on that, and based on the cases that we provided to the court, we'd ask the court to deny the motion for new trial. The only thing I'd like to do, because I'm driving and I don't want to read it, I don't know if Mr. Flores is there, but there's one case I think that's on point on this issue. And if you could just briefly give the court a summary of that so the court can then either read it or make note of the summary that we're giving to you, Judge. And I don't know if Mr. Flores is on the line right now.
All right, Mr. Flores.
Yes, Your Honor. Just briefly, Judge, on the issue of the motion for new trial, with regards to failure to have counsel present, the case that we presented to the court discusses that issue. And the bottom line is the burden is on the movement to show that failure to have counsel was not as a result of her own negligence. And so according to the facts as stated by Mr. Salinas, she had more than 30 days to obtain counsel. The court had actually admonished her to have counsel present at the final hearing. Her failure to have counsel at the final hearing is indication of the fact that, you know, the court had no fault in her not having counsel at the final hearing, number one. Number two, there was no motion for continuance that was on file. She had more than 30 days to file a continuance after her counsel withdrew. There was no motion for continuance on file at the time of the final hearing, nor did she urge one at the time of the final hearing. So with regards to the legal aspect of not having counsel, that case talks about exactly what I just mentioned to the court, that the burden is on her to show that the failure to have counsel was not a fault, was not her own fault or her own negligence. And she's just failed to meet that burden.
And do you know the name of that case?
We provided it to the court, Your Honor.
Okay, then it's in your response.
Yes, Your Honor.
Yes, Your Honor. In response to that, it is clear if the court will look at the records, and that's what I asked, the transcripts, the video. I have access to the video from YouTube. She, on many occasions, requested from the court to please, and she almost went to the degree of pleading to please allow her, that she had not been able to get the resources because he had paid for Ms. Thompson and then had cut off the payments. There was no more payments. So rightly so, Ms. Thompson withdrew. This case, they keep saying, was filed in 2020. It's super old. I mean, to me, being old, this case was filed in April of 2021. If anything, this case was heard extremely fast. Ms. Thompson filed her motion on March of 2022. This case was then heard on a final hearing just a couple months later, just less than a month later, in April, not giving my client sufficient time. How that is of her fault or her negligence is beyond me. The thing, it is not only that, Your Honor, but because of her not having the ability to get an attorney at the time, she did not know or did not put any testimony, and neither did Mr. Varela, though, as to anything from Dr. Quilantan saying that it was in the best interest of the children. In fact, until recently, they had been following the provisions of the temporary orders, which provided that he was to have the extended standard. There is nowhere in this file where you will see that she was trying to give him less time, more time, nothing, Your Honor. And I bet there was at least on 10 occasions that I counted on the record where Mr. Salinas said, all we're trying to keep as to visitation and custody and possession is what's in the temporary orders. None of that was done. There was no testimony for Dr. Quilantan to say that it was in the best interest of the children. There was no discussion as to any finance, nor did they present any evidence in any way to show how properties were divided, anything of that nature. I would just plead with the court to please review the record in this case, Your Honor. It's very, very clear.
Your Honor, can I just briefly respond, and I won't replow again, I think Ms. Williamson argued that already. Let me just say this, that my client testified that it would be in the children's best interest, all right?
Oh, really?
And in fact, please don't interrupt me, Ms. Williamson. The other thing
I didn't talk to you, and I wasn't interrupting you.
Okay, and then my apologies. The only thing I will tell the court judge is that Ms. Williamson's client was not gonna show up to the hearing. I had to call her the day before and tell her show up.
Your Honor, that's totally unnecessary for this hearing, Your Honor. That's his assumption.
Ms. Williamson, please. You've got a nasty habit of doing that all the time. And I
can tell you, and you don't, right? Because you're perfect.
Can I finish? I'm telling you, Judge, as an officer of the court, I called her. We could have defaulted her. And again, I'm only doing this because Ms. Williamson is arguing outside of the record. I'm just saying, Judge, get the record. Forget about everything I said or she said. Take judicial notice of all the pleadings on file and the history and the docket sheet. Use your independent recollection, Judge, to help you determine whether or not that day she had an opportunity. Mr. Flores is correct. She didn't file a motion to continue. All right. She had a lawyer. The lawyer withdrew. I disagree with Ms. Williamson for other reasons. She showed up that day because I pleaded with her to be there or we were going to default her, and that she had to be there with a lawyer or she had to be there to argue her case, because those are the orders that you had given us before. On the motion to reset for the final hearing, you gave us that in consideration of the fact that Lucy was withdrawing. And that's what I'm saying. I mean, we can argue outside of the record all day, and I don't want to be disrespectful with Ms. Williamson, but that's what she's doing. And what I'm saying is, if you look at the case law and just look at the record, Judge, there's plenty, I believe, to deny their motion for new trial. That's all I'm saying.
Okay, and I think the case I was looking for earlier was Jordan Nolan versus Nolan. It's here on the response. All right, then, court will take judicial notice of the entire file. Court will go ahead and take this matter under advisement. We'll look at the record again and then come up with a solution, hopefully an answer later this week. All right.
Thank you, Judge.
You all may
Thank
be
you, Your Honor.
excused.
I have nothing
Thank you.
further if I could be excused.
You all may be excused. Have a great day. Thank you.
Thank you.
Bye-bye.
Thank you.
What do we have now?
Number one,
Number one.
bench trial and motion to compel discovery.
All right. Number one, let me see here. Court will resume here. Court will resume with the June 6. Court will resume with the June 6, 2022 docket, and I have here CL 20-3339D, Chance Bontin versus Adrian Guerra, and we're set for bench trial. Okay, good morning, Mr. Trevino. Can you hear me?
Morning, Judge. I can hear you. Perfect.
All right, Mr. Vantine, can you hear me?
Yes, I can hear you.
All right, good morning. Yes, sir.
Judge,
yes.
Current status of the case is that we're still conducting discovery. We've sent a request for a second request for production and inspection. In our discovery, we requested from Mr. Chance, and he sent us one account number, the statements for one account number, which we just got last week. Currently, we're trying to track and trace the money that was sent out or paid out by my client. And that's why we're needing the other checking accounts that appear in the statements that we received from Mr. Chance?
Vantine.
Mr.
Vantine.
Yes. And we haven't received those statements. Now, the only way that I see for this case to maybe satisfy everybody is that if we can track or trace that money wherever it went to, then my clients might be in a position to fill out the application for the government's help if in fact Mr. Vantine, but we can't get there unless we receive the statements from his other accounts.
Okay, I think earlier, I think both parties or one of the parties was seeking a remedy from that assistance program.
That was me.
That was Vantine. But
okay.
At that point in time, I could not allow my clients to submit any application or sign any application because we don't know where that money went out to. If in fact it go Vantine, then my clients couldn't legally apply that money. And so we requested those accounts from Mr. Vantine so we can go over them and see if we can find out what happened to that money. There's no dispute that my clients have been there since October 2019. So, I mean, my client's contention is that they're still paid through this month and requiring one extra month to find another place. They should be, that will probably happen by the end of July. So the only thing that we'll be contending for is the monies that Mr. Vantine has not received.
Okay, Mr. Vantine?
Yes, sir.
Yes, sir. Your response?
Okay, so I've never received any monies for the last 2 years, so he requested the account that was attached to the Cash App account. That's what I supplied, was my bank, all my bank statements that are connected to that Cash App account. Okay, does that make sense?
We requested all
Last week.
in your possession.
Last
and we
week.
Second request of those documents. So it wasn't just one account. That was the reason for the discovery. We don't know exactly how many accounts you had.
Well, you specifically asked for the Cash App account on April 13th. You asked for the account, the statements of the account connected to that Cash App account that was paid, supposedly paid.
Exactly, and from the account that you sent us, there's transfers from the Cash App account to other accounts connected to you.
I don't know why you think that.
So we need those others to trace or track the money, try and trace where it went off.
I mean, I'll send you those accounts, but they are not connected to Cash App.
Well, our understanding is a little different. I'm not saying that these monies or funds that the Guerras paid were connected to the other accounts, but we need to make sure that that's not the case.
I mean, that's why I specifically asked in discovery for you to print out from your computer the bank statements from Mrs. Guerra from that account, because I know that those are false.
Well, we provided those. You've had them.
Yeah, but they're false. If you printed them out from your computer and had the login, then we would show that they don't match.
Yeah, well, we didn't print them from our computer.
So what? Those printouts came off straight from the bank or what?
Yes, sir. Yes, Your Honor.
No, Your Honor, these statements are the ones that were submitted as evidence that I'm complaining that submitted as false evidence. So I asked in discovery for the Guerras to print out the bank statements again, new from Mr. Trevino's office, so that he can see that they don't exist.
Those are those statements that we provided to Mr. Bantine were from Mrs. Guerra's checking account. They came straight from over there directly. Yeah. And those are the ones that have been going back and forth.
What bank is that?
That's Wells Fargo Bank.
Wells Fargo?
Yes.
Okay. Okay. Once again, this is an appeal from JP Court?
Correct.
All right. And in JP Court, which JP Court was that? Who was the judge? Anybody remember?
Oh my gosh.
Was that the Munoz Court? Or
I believe it might have been the Munoz Court, Judge.
Jaime Munoz Court. Okay. What was the ruling of that court?
It was one judge one time and then another JP later. That's why I can't remember.
Oh, okay.
Like Pena,
the ruling was
Pena. There's Peñas. Okay. There's a judge named Pena. There's two of them. One in Mission, one in Edcal, Chelsea.
Well, it was in Mission. Yeah.
Okay. That's JJ Pena, I think. And what was the ruling of that judge?
Rulings were for my client, the Guerras.
I'm sorry?
The ruling was for my clients.
What was the ruling? Yes, what was the ruling?
I don't recall that specifically, but they were not evicted.
Yes, they were. They never showed. They did not appear.
Well, wait a minute. Within Mr. Bentime won at the JP Court level.
Yes, Mr. Bentime went into the JP Court level. My clients did not. Apparently they had a trial set. My clients did not receive notice, and they appealed that, and that's where I believe it came to this court.
Oh, okay. So then Mr. Bentime won at JP Court, and then the Guerras appealed.
Correct.
All right. And what did you win at JP Court, Mr.? What was the possession of the property?
Yes.
Plus any money?
He put a $3,000 bond, but I don't know if the.
But you were awarded the property plus any money?
$3,000 in a bond that had to be paid.
Yeah, but the $3,000 was for the unpaid rent.
Well,
My understanding was it was a bond.
Okay. All right.
So he did not, I don't think he awarded me monies.
Okay. So, so in this case, you're seeking again the possession of the property, right?
Yes.
Okay. And what is the amount you estimate or you think they owe you on the rent?
Last month it was 48,000. So now it's 49,600.
49,600
Correct.
rent. And this is from what time, what date, from what date to what day?
Okay, 1 second. I have the statement right here. Okay. It's from November 2019
November 2019, okay,
to current.
to current, which
June,
is
June 2022.
Okay.
2022, excuse me.
All right. It's supposed to be $1,000 a month?
1,600.
Oh, 1,600. All right.
Correct.
And then you're saying they owe you, oh, that, okay, the 16, okay, the 49,600 is equal to how many months?
That would be 33 months. Oh, 30, sorry, 31 months. 31 months.
31 months at $1,600 a month. All right. And so, and the property has always been yours, or did you get it like at a foreclosure or what? What?
Yes, I purchased it from the bank after it was foreclosed on.
Purchase from bank. All right. And specifically, where is this property?
2105 Azalea, which is Azalea Street, Mission, Texas. 78572.
2105 Azalea. And this is Mission, Texas. Okay. And specifically, do you have like the lot number and everything else, subdivision, anything like that?
Yeah, I can give that to you. Just
All
give me
right.
1 second while I look that up.
And when I open up the file, I guess I'm gonna be finding all this information anyway. But anything I can get right now
Sure.
would help me out.
I'm pulling it up. But it is spelled incorrectly in the CAD, if that's where you're going to look for it.
All right. On the county CAD?
It's spelled Azalea. And so there's a 2 letters backwards.
Okay.
On the Hidalgo County appraisal district.
Uh-huh. And that's what, lot block number?
Yeah, okay. Taurus Estates number 9.
Okay.
PH3, lot 110.
Lot 110. There you go. What was it? What was the estate again? Taurus?
Taurus, Taurus Estates number 9.
Estates number 9. Okay, there it is. Lot 110. There we go. Which equals to 2105 Azalea, right?
Correct.
All right.
Mission, Texas.
Okay.
I don't know what the zip code, if it's 78574, I believe.
All right. All right, Mr. Trevino, and you're claiming that you guys are current on the payments?
My clients are current on the payments through this month.
I mean, we have a big difference here, 49,600 versus 0?
That's correct, Your Honor.
Uh-huh.
Huge difference.
And
Another
that's
thing,
I'm sorry?
Oh, one
That's
other thing, and no, you know, that a lot of discrepancies, right, in these bank statements, you know, when you look at my bank statements, they say money transfer, they don't say cash app for the amounts, right? And on their bank statements, they say cash app. But
the code number.
But I'm just saying, you know, the times that I've used my Cash App account, when it does make a transfer, it doesn't show up as Cash App, it shows up as money transfer.
Mhm.
In their bank statements, it says Cash App. So it doesn't make any sense. You know, none of this makes sense.
Mhm.
Because they haven't paid, they made up those bank statements.
No, Judge, those monies were being deducted from my client's account as the statements show. So those monies went somewhere. And that's what we're trying to get to. Where did
I gave you Mr. Trevino, I gave you all the statements for my Cash App accounts. The only place they could have gone was Cash App, my Cash App account.
There's several Cash App account pages missing, which we have provided you with the pages that were missing.
You know, you said 2 months. You said September and October of 2019, which was before I even received money or spoke to Mrs. Garrett.
And we had September of 2021, December of 2021.
So what about all the other months from December? Okay, you're saying that I'm missing 2 months, and all those other months from January up to this date, I have not received it.
Those are the ones that we don't have. Now, all the others we do have.
And none of them show up any payments from Mrs. Garrett.
Yes. There was 3 of them for, I believe, a total of about 5,000, 3,000. After that, there's no other indication on what we have, on the information that we have, that those monies were deposited through the Cash App.
Yeah, those $1,500 you're referring to was for rents from October.
But the way the Cash App can have that money deposited in whichever account you want, just provide the code number to the Cash App account.
Mr. Vino, I have it connected to one account, and that was the account that I supplied to you, but it doesn't matter.
You can link it up to whatever account that you have. You have 5 or 6 accounts. So that money could have gone to either one of those accounts.
Well, Mr. Trevino, did you file anything with the court as far as exhibits?
Judge, the earlier were the ones that we filed, but we were still conducting our discovery, which we have not completed, which is from Mr. Bentine, so that we can file with what we have. And so, you know, I mean, our understanding, Judge, is that, I mean, something else could have happened, some scam. If that's the point, if that's what actually happened, then my clients would be in a position where they could fill out and sign up on the application that Mr. Bentine needs to submit to the government to get reimbursed. But we can't not get there until we see and where the monies from the Wells Fargo's account that Mr. Bentine provided to us went to.
So you can still apply for assistance right now?
Yeah. The statute, it's extended. They extended the statute.
For how long?
I don't recall for how long that was, but that's where we're at right now.
I mean, I feel stuck because they have not contacted me. It just says pending new application.
We just received it this past week.
Okay. Now, something about the governor's direction or some kind of I know that early in the year, I think, where if anyone is applying for assistance or or is in the process of getting assistance or made an application, that there should be no trial or no. Anybody heard about that in that ruling?
No.
That was done earlier, but I don't know if it still exists or not, or is it still going on or what? Do you know, Mr. Daniel?
I have to look for it, Judge. I had it here and
I mean, they were giving directions to the court not to have trial or anything until this thing, if somebody's applying for something, let that process go. And then after it's finished, then you can have a trial or something like that.
Okay, well, Your Honor, I mean, I don't have a problem with that as long as you sign that order, making the Garris pay the court to me. You know, as long as I'm getting my rent, I don't care if it takes 6 more months or however long this process takes.
I believe the Garris are ready to move out by the end of July.
I'm sorry?
I believe the Garras are ready to move out by the end of July, so that we can take that part off or out of the equation.
Well, no, I want the money paid to the court.
Yeah, and I guess I'm thinking here, you know, I'm thinking of some kind of a judgment here that the court can do, but I need to look at that direction that the court that the governor made earlier in the year, where that can't do a ruling until something is concluded with the parties are through with their assistance. Or can I do a ruling? Because if I can, I'll do it right away. But if I'm going to make a ruling that the governor is going to, that it's not going to be valid because of the direction that's going on right now, directive, then it may not be any good. Maybe a partial judgment where you get possession right now, and then the other have a trial on the actual numbers.
Yeah, that would be something we might be able to work out. But like I said, my clients will need until the end of July to find a place. They're claiming that they're paid up through this month. So if they move out by July, the end of July, if they were supposed to pay this month, next month, they're still going to be on the hook for the total amount once we go through all of that and sit down or make the deduction to the money amount. So we can.
Well, you know what? Maybe I can make temporary orders right now, whereby Mr. Valentine gets possession of the house at the end of the month, and the trial is going to be later on until we get some more numbers. In other words, no final judgment, but there'll be temporary orders for them to vacate at the end of the month. And then let me wait on the numbers. I don't know anything about the numbers yet, and set that for trial down the line. Okay, let me do temporary orders. So, Mr. Trevino, can you do those temporary orders for me?
That would be what, Judge?
That they vacate by the end of the month.
I'll need a little bit more time than that to move all the furniture and stuff.
Well, we're already on the 5th, the 6th?
6th.
That's let me just say by the end of the month for them to get out at the end of the month, and the trial is still pending. June 30th. It'll be June 30th. Is what? What day is that? Is that a Thursday? June 30th. Temporary orders, and then we can continue with the trial later on the numbers.
Okay, so am I going to need to take this order to the sheriff's department?
Well, no. Temporary orders are this, that they vacate, and if they don't vacate, then that you are entitled to all writs and for possession.
Okay. So if they don't vacate and obey your order, then I need to get rid of possession.
Yeah, get writs of possession, right?
From your office.
The same order is going to order that writs be issued if you need them. Okay, Mr. Trevino?
Okay, we'll prepare the orders that the court is wanting, Judge.
That all necessary writs are hereby also ordered. All right, so let's do that for temp orders, and then we'll come back later for the trial on the numbers.
All right, Judge.
Thank you, Judge.
All right, thank you very much.